This is Radio Havana, Cuba.
This is Radio Pyongyang of the Democratic People's Republic of Korea.
This is Moscow.
Hello and welcome once again to Crazy Talk. It's me, your host, Doc Normal. Not my real name, but it's my assumed name. And since tonight we have a lawyer here, maybe she can help me out with my legal difficulties. I don't know what that means. So, let me fix that, thank you, so I don't hear myself echo. It's been an eventful week. I was reminded that last week was OS Bridge, so no events happening this week. Finally, kind of taking it easy and not podcasting or live streaming any events. Actually been posting a lot of interviews, a lot of things from Web Visions, the keynote from Merlin Mann, keynote from that wonderful keynoter from Brooklyn, who I can never say her name, and several interviews, a lot of good stuff. We also posted the Mayor Sam Adams keynote and interview, and there'll be more OS Bridge stuff coming up as well. So more panels from Web Visions, more content from OS Bridge, and it'll be a lot of fun. Speaking of OS Bridge, someone I met last year at OS Bridge is our guest. Her name's Paula Holm Jensen. She was at OS Bridge last year. She was there this year. It's always nice talking to her. She's a lawyer, and she's been a speaker at OS Bridge for a couple years now. Paula Holm Jensen is a Portland lawyer practicing in the information technology and intellectual property fields. She's worked with several of the best firms in Portland, but has been solo for 5 of the last 7 years. Her main focus is on technology transactions, development, licensing, sales, manufacturing, marketing, distribution. Other interests include copyright, privacy, and open source. Therefore, a speaker at Open Source Bridge for the last 2 years. Her clients range from individuals to Fortune 500 companies and small private companies. It's really great to have her here tonight to talk about intellectual property, open source, and some other things. Paula, good evening.
Good evening.
And I totally didn't have the mute button ready yet for you.
All righty. Well, good evening, Doc.
Well, why don't you tell us about Open Source Bridge? And I should mention you are here live in the studio, which is always kind of interesting for me. Usually it's like I got a couple cameras and we dial in some Skype. So, but you like to come in and do it live, which is always good. We like that when it works out.
Yeah.
So why don't you tell us about your talk last week at Open Source Bridge? You gave a talk, and I believe your partner gave a talk as well. So you talked about open source, kind of how you have the day job and work on outside projects, and how you're able to kind of manage those things, especially with, I imagine, intellectual property, essentially, having intellectual property come in from your day job into your project and vice versa.
Yeah, that can be the problem. So the talk was entitled Moonlighting in Sunlight, because the idea was, okay, you're moonlighting, but it should be out and open, transparent, sunlight disclosed to your employer, and hopefully both sides can deal with that. There are intellectual property issues if you're dealing in a technology company, software, anything like that, and anything creative. So it's not just the technology side, but if you're creating things at work, your employer wants to own them, should own them, is paying you for them, so, probably that's the correct thing. But when you're creating something on your off time that is not for the company, you should have the right to control who owns that, whether you own it, whether you contribute it to a project. And it's not just software development, although I think that was the main concern for folks at Open Source Bridge. It's blogging, it's doing things even like you are now.
Yeah, you just mentioned creative, and I'm familiar working for a technology company about the IP and source code and those types of things. But run down some of these examples of creative, like blogging or podcasting. What's an example?
I think blogging and podcasting are two of the examples that are fresh on everybody's minds right now. Maybe just because they're newer and hot right now. But they lead to a lot of crossover issues. If you are a programmer or, anything you do in your day job, typically if you were writing a novel in your free time, that's not something your employer is going to care about. But with the doing art, if you're a photographer, if you're even a graphic artist, a painter as well, unless your job somehow relates to music. I don't know if music would get pulled into something like that. But in particular, in the areas of blogging and podcasting, where you are talking about either technology, business, kind of the state of the world, or your personal life and your personal concerns, you can cross those lines between what's personal and what relates to the company a little too easily. And that's where I think companies get paranoid. Either that you're going to say something bad about them, or reveal information that you're not supposed to, trade secrets, confidentiality. You can talk about doing a deal with X and such, and oops, that was supposed to be confidential. Nobody was supposed to find out about that.
So have there been any... I know there are some famous examples of people getting fired because of blogging, talking about their employer like that. And I think that seems to me... It seems rather obvious to me, not obvious to other people, but a lot of companies, and I know the company I work at, have blogging guidelines, have NDA confidentiality guidelines, and they drill that through your head. So unless you're not completely insane, you pretty much get that I am not going to go up to my personal blog and talk about this big deal that I'm doing with X and Y, right? But are there what interests me more, are there kind of fuzzy areas about talking about my personal life that doesn't have to do with the company, but makes the company uncomfortable enough, or reveals something about myself that doesn't jive with what the company's doing, and therefore people get into legal trouble or get fired or something like that. Can you think of some examples?
Yes, more in the general than, or in the abstract than the specific, other than the original, possibly the original one, for whom, this syndrome, this problem was named, deuced. Mm-hmm. That's mm-hmm. being fired for something you write in your blog. And
what did she write about exactly?
I haven't looked at it for a long time, but it was not incendiary. It was very mild by today's standards. It was just so early in the days of people blogging. It was very early 2000s. And that her company was just upset that she mentioned them at all, mm-hmm. even though what she said was not negative. But there are two sides of it. There are the things you say that can get you fired, and that can be almost anything. Unlike what people may think, if you're in a real, and this is not my area, this is employment law, but I picked it up from, I've picked it up from especially the guy who presented with me, who did the employment law side of it. But basically, anything that isn't a protected category, gender, race, age. In Portland and Oregon, you've got a few others, sexual orientation, things like that. Unless it is related directly to a protected category, you can get fired for anything. It's employment at will. And if you say something that the company doesn't like, under normal circumstances, they can fire you, even if it's not, even if you wouldn't think of it as being a problem, even if it isn't one of those things that does directly create problems for the company, like breaching confidentiality and trade secrets and or trashing the company.
So what you're telling me is that when I want to write about this big deal that I'm doing at work between company A and B, I want to like couch it in like religious talk and maybe some gender orientation type talk as well.
You can try. There was actually an interesting thing that happened fairly recently here in Portland that Mark and I talked about before we did our presentation, and that hit the Twitter sphere and blogosphere a fair amount. But a vegan bakery in Portland put out, I believe via Twitter, a job advertisement saying they wanted to hire a barista, I think it was, and for the bakery, and they said being vegan was a requirement, and people were buzzing. It's like, can they do that? And the answer is probably yes. It's probably a bad idea. It's probably better to just say it's, knowledge. You have to know about it or be willing to learn about it, and there's certain requirements that they could put on, and they, could probably say vegan is preferred, but it actually would not be illegal to say vegan is a requirement, because it's not one of those protected categories.
I think it would be much more interesting if they'd find that unique vegan butcher that they could hire there. I mean, they get new people through the door, just as long as I guess he washed his hands a lot or something like that.
Well, just think about the sensitivities of that situation. Okay, you can't wear your leather jacket to work. You can't bring even an egg salad sandwich, much less tuna or roast beef.
Don't bring yourself to work, because you're meat, I don't know.
Yeah. But, yeah, so we were talking about that. But getting back to what you say affecting your job, anytime, well, you can't use sexual orientation anymore in Oregon,
sure,
or at least in Portland. I can't remember exactly, but that
Oregon
one is
Constitution, right? Probably. Oregon Constitution?
No, it's a state law. Yeah, okay. No, the Constitution in Oregon is good in many ways, especially as we heard last week on the free speech side. But that's not actually in the Oregon Constitution. But if you reveal something about yourself, here you go. You're a Lakers fan and your boss is a Celtics fan, or maybe even a World Cup. Analogy right now would be better, but I think the basketball playoffs are still going on, and you start talking about how much you love the Lakers. Your boss could decide, I just can't have any Lakers fans in my company or in my department. So, Doc, you're just gonna have to go.
Wow.
It's unreasonable. It's unlikely, but it's one of those things that's not protected. So if you're an at-will employee, they could.
Yeah, it always struck me that whatever job you have, if they want to find a reason to get rid of you, they will. They
don't even have to give a reason,
right?
Really, and that's the whole thing about at will. But as I said, this is not my area of law specifically, although it bumps into my area a lot, because talking about what employees can own and what they should own and the confidentiality. But any of those personal things can be used, but it's when you stray over the line of revealing confidential information, intellectual property, trade secrets, talking about a process that the company has invented that makes widgets faster,
So here's a weird kind of litmus test that I have, and you probably laugh at this, but I have a background as a musician, a composer, and I've signed NDAs and all of the IP and all of that when I joined the company. Now, my company does not make music. It makes machines. People use the machines to make music and other things and documents and spreadsheets. But so I write the great, symphony, or I write the next great American novel while I'm working for my employer. Where do you draw the line? I mean, can the employer actually turn around and say, hey, you know what? That's our novel. Thank you. I mean, and you see, that's a very drastic point, but maybe you can also give us an example where the line is not so perfect. A company that would say, hey, you know what? You did this, and we actually were going to go into that business, so that's ours too. Yeah.
This, interestingly, the day after my presentation at Open Source Bridge, some other lawyers in town gave a talk that I went to about this, employer land grab, if you will, what employers can and can't take, or require their employees to sign over to them. And Oregon does not have a specific law that speaks to this. They've had some cases in the past, so we kind of know some of the rules, but not a lot. Both California and Washington have laws that are very, very similar. Not quite identical, but pretty darn close about this. And I think most companies, probably just because their lawyers tell them to, but most companies will stay within those bounds. And that's basically that if you use the company's equipment or do it on company time, it'll belong to the company. If you don't use any company resources and you do it on your own time, it'll only belong to the company if it relates to their actual or demonstrably anticipated, I think is the phrase, research and development or product plans, or it directly relates to the work you were assigned to do. So I think most of that makes sense. So that would exclude the novel, the symphony, the example the lawyer used in the talk we were having is her husband works for, and I'll leave out the names, although she didn't, a semiconductor company, a small, up-and-coming, very aggressive semiconductor company, and they have a more aggressive assignment requirement in Oregon than they could in Washington or California. And say the husband invented I think the example she used was a bread machine. And that wasn't related to the company. It wasn't a semiconductor that made the bread machine new, that made it really do something special. That wasn't the invention. But under the language of the agreement he'd signed, they could claim that because it was an invention and he made it while he was employed by them. And the question is, in Oregon, would that stand up? We don't have anything that would say absolutely not, so we just don't know.
Is that is the reasoning behind that the company is just covering their bases, just as a blanket statement, just to cover their bases and make sure they see what's coming out of it?
I think that is most likely the case. I really doubt that this company would want to go into the bread machine business or would try to prevent him from going into the bread machine business unless, of course, it took him away from what he was doing for them. But most companies are not that aggressive. Most companies do look at it and say, we want what you do for us. And yes, that might extend to some business we're not in now, but that we could be going into. And that's always the tough part. I think that's why they say demonstrably anticipated. The company can't just say, yeah, we're going into that business. Yeah, that's right. They have to be able to show, oh no, we talked about this at a board meeting 6 months ago, that we were going to investigate going into this, or just something that I haven't, frankly, I haven't read any cases or seen any cases that really go into what demonstrably anticipated means, but that's kind of what you guess. it would mean. They have to show something, that it wasn't just a grab out of the blue. Because I think there are a lot of gray areas.
It seems to me like it's easy in high technology when you're talking about like semiconductors, where you actually have patentable IP, hardware type things, even source code and software. But when you get on the web, and a famous case would be Facebook, for example. Cases against Zuckerberg, where it's claimed that he did not, he took that and turned it, basically had partners in college, and took the idea and turned it into Facebook and screwed his partners. Yeah,
and a lot of that is under seal. They're confidential settlements, so we don't know the truth, the legal facts of it. A lot of people have background information on it that certainly seems to indicate that a significant portion of it was somehow borrowed, stolen, developed at the same time, that it may not have been completely on the up and up. But what I don't know for sure is, was this unofficial enough? Was he employed? Was he paid? Did he have an agreement that said, should the rules for inventions, things that are patentable, and copyright? So most software you'd consider to be copyrighted, although software can be patented, but what you normally think of when you think of software is copyright. The rules for the default of who owns that, if you're an employee, are different. So that's one of the things to remember. If he was an employee, then what he wrote should belong to the company. But if this was just a bunch of buddies sitting around, there may not have even been a company. I don't know for sure. I haven't. I don't remember the facts of the case. The Connect You, I think, was the original. Yeah,
that sounds about right.
So I don't know if it was a company or if it was just a bunch of guys who were trying to put together something, and whether there were any agreements. So, what the default rules might have been.
Well, it just seems, too, and we've seen so many odd types of patents, for example, that have come out of software over the last, couple decades. And it just seems like on the web, it's really a free-for-all, and if you have a company that does, one type of website and then turns around and does another website or website design and can claim, can make claims there. It can say, hey, that's our type of design, or that's, it's just trying to figure out where the breaking point is in the law,
Yeah, and the law's been breaking a lot lately.
Okay.
One thing you have to remember is the law's always behind the technology.
Sure, absolutely.
It takes a long time to catch up. Right? Yeah. The faster the technology starts moving, I think the law has not reached the level of, it not only is it behind, but it's falling further behind because it can't accelerate fast enough, because the technology is accelerating even faster. So it is lagging behind in a lot of ways. And one of them, we do see a lot of fights over patents for things that happen on the web, silly things like Amazon's one-click.
Yeah, that was the one I was thinking about, one-click, which was considered somewhat an outrage when that was patented, because it was like, are you kidding? One click, you patented that? Well,
And after all the noise quieted down, they actually got their patent. And it may have been eviscerated. It may be very weak now. It may be on just, they may have written it to cover this, and it may only cover that. But I think they've... I think they said they would refrain from suing anybody.
Sure.
That they wouldn't. Sure. When things got hot, they said, "Oh, we're not going to sue anybody over this." And I think they haven't. So
it becomes an armament rather than an
defensive.
Actual, part of a portfolio that's defensive or offensive when you need it.
I mean, they wanted, at a minimum, they wanted nobody to be able to take that away from them, even if they weren't going to go after anybody else. And that's, in general, I'm somewhere in the middle of the IP spectrum as far as how much protection I think there should be. I'm not an absolutist on either side. I'm not completely, there should be no intellectual property, because I think it does serve it's in the Constitution. It's one of the few things that actually says a right, that's actually written in the Constitution. But it's supposed to be an incentive to get people to do things. It's supposed to be that little bit of extra incentive to get people to go out and do things, to expand knowledge and the useful arts. And yet, what's happened is that it's been taken way too far, that it's been expanded. Copyrights are now, life plus, life plus 75, or 95 years for a corporation, or an anonymous, for a non work without a person attached to it. But it used to be, 14 years, and maybe you could double it to 28.
So, another question, moving into more intellectual property, as crazy as the web is, it even gets crazier. Dandelions. So dandelions are the thing that wispy, right? You blow them. Okay. A farmer raises dandelions, and he sells dandelions, and they're very, very, these are very fine dandelions. He's very successful. After a harvest, a company comes and says, the dandelions that you sold and raised are our genetically modified dandelions, and you owe us a great deal of money from the profits of your dandelions. Farmer has never bought these genetically modified dandelions, but come to find out the farmer next to him was using them, and the dandelions blew into his farm, his wonderful successful dandelion farm. Your comments. Yeah.
This again is where I come down somewhere in between, possibly more on against the rights of the intellectual property holder in this case.
But this is the cutting edge of IP now.
It is.
It's genetic modified animals and
definitely. But you've got a couple things going on here, and one is, by the way, this is real. This describes several real situations that have yet to reach their legal end. So we don't know what the courts are going to say about this. So I don't have a nice little pat answer I can pull out as far as what the courts have said the answer is. But yeah, in the strictest sense, that person has infringed the intellectual property of the patent holder by reproducing their patented plant without their permission, without paying royalties. So in the strictest sense, absolutely, they owe the money.
So in the future, as you know, being in technology and software, sometimes it's hard, especially working with open source, and there's been some famous cases of keeping intellectual property and copyright code out of open source. How in the hell are you going to do that with genetics?
Yeah.
It's next to impossible.
It is, especially in the plant, in plants that are non-sterile. I mean that's, and then you get into I don't want to get too far into the whole bit about this seeds that genetically modified seeds that will not reproduce, so you have to buy them new every year.
Sure.
But for ones that will reproduce like that you can't control, that is it is lawsuits all over the place waiting to happen. Also, it affects organic food. If I think I'm growing something organic and the guy across the way is growing something non-organic and it wafts across into my fields, what am I supposed to do? I've now lost my organic certification, which was worth millions or at least hundreds of thousands to me as I built these things up. And how many years does it take to get an organic label, the ability to call yourself organic.
Would that organic farmer, non-GMO farmer, would they have a case?
They're still trying. We don't have an answer. Yeah.
What a mess.
But they are trying they're trying to stop it before it happens, for the most part. But yeah, that is for things you can't control. You also get into the nightmare scenarios, the super bugs, and whether that's germ type bugs or whether it's literally bugs. That's the stuff of horror movies.
Right. Yeah.
And it's getting closer. It's getting at least possible.
And I just imagine how it affects us, animals and humans, and at some point down the road, part of our genetic makeup, our ancestor, our great grandkids may have intellectual property inside their bodies, and I can't imagine a world like that. I can't imagine sort of a litigious world like that.
Yeah.
It would seem like people would be suing people constantly. Are those jury trials that are happening in those types of cases, and how does that work?
It depends. A lot of when you have an agreement and you have a breach of an agreement, sometimes you have something in the agreement that says how you're going to handle disputes. When you don't have an agreement, the parties have to, under most circumstances, that you have a right to a jury trial, even in a civil case. So this isn't criminal, where you definitely have a right to a jury trial. But in civil cases, in most states, actually I don't know if it's most anymore, but in a significant number of states, you have a right to a jury trial. It's not just heard before a judge. I don't know when it's better to have a jury trial and when it's not, because you have the balance of people assume juries are going to like the little guy, which is not always true, especially when the big guy is a big local employer, or they can analogize from the big company to a different big local employer that might affect the economy. So juries aren't always more favorable to the little guy. And then you've got the balance of people who are not educated to the level of understanding the scientific bases. And I'm not trying to insult anybody. I don't know if I could get through on the genetic side. I don't understand that stuff. I have a very, baseline knowledge of chemistry and biology, but I don't understand that stuff.
Well, and that's exactly why I asked the question, because I think as we get further along and, even talking about intellectual property and making semiconductors, software, and certainly genetics, your average jury pool, even if they are well-educated, are not content experts.
Yeah, even the juries, in Portland, who are pretty darn smart, other places where you have really high levels of college-educated and better, there are certain levels of this technology. So you bring in experts, and they found that even, people do understand, can be taught to a certain level. They decided a while ago that patent cases should be tried at the first level. They're all tried at the same level as any federal case, but there's a separate appeals court, and that's the level between the first trial and then the Supreme Court. But there's a separate appeals court for patent cases. They just decided it's too hard. We need people who focus just on that. So the first level, the trials, are held in front of regular judges. You might get a special magistrate who has some technical knowledge or who can take the time to sit down and learn. And the judges can bring in subject matter experts to help them out, neutral subject matter experts to help them out. But at least at some point they decided, hey, we need at least the appeals court, the people who review what the regular court is doing. At least those guys will try to pull them all together, just have one group who always looks at those. So they've done a little bit of that. There's been some discussion as to whether there should be a separate trial court for patents and other technology things.
Well, as a growing, I imagine a very, very large part of the law that's growing continuously, and like we talked about genetics and those types of things, it would seem like it would be a good idea.
It's either going to get much, much worse, and there's plenty of science fiction stories about societies that are so tightly controlled that you can't. You can't even control your own body anymore. You can't control your own future and your own physical integrity anymore, because everything you do is controlled by the companies or the government, obviously, in some of these dystopias. But there are enough stories about that. So it's either going to get much worse, or at some point people are just going to have to say, we have to relax on the enforcement because we can't keep tightening it down, or else, we would be in a position where you can't even, cut your own fingernails without collecting them up and sending them back to the patent owner.
Well, I hate to say it, but I don't see that trend happening. I see quite the opposite. The government and the law, quite the opposite. That control and making sure that every aspect of life is shrouded in some sort of law, and we're always told that this is because it's a post 9/11 world. Well, I think that's gone a little far, in my opinion.
I would not
no
disagree.
offense to you as a lawyer, but
it is sometimes the lawyers. It is not always the lawyers, and there are a fair number of lawyers who are also working in the other direction. People who do try and fight these things. By the way, there was one successful case recently saying that genes, under certain circumstances, a set of genes could not be patented. This was a case in New York. As I said, this is the first level, the trial level, and it'll next go up, and I'm certain it's going to be appealed up to the patent. It's called the Federal Circuit, to look at the patent because it's a patent case. But they basically said it related to a test for a type of cancer, but they had patented the gene that they were testing for.
Sure.
And it was just held that was, you can't, that was not patentable subject matter, is the way it's referred to, because it was something of nature. They didn't, it wasn't an invention.
So that, to clarify, that particular gene, that cancer gene, appears in nature, and it was not actually genetically engineered. That would be the difference, as opposed to a genetically engineered,
correct.
Something that's genetically engineered.
Yeah.
That you said this was done with engineering, and I certainly can patent it.
Yeah, I don't even. Yeah, it's actually. I think it was one of like the marker genes for something, and so you run a test on it, and it tells you whether you have type A or type B of a particular thing, or something like that. So it was more even like that, not even that it was the cancer, but that it was a marker for something. And it was, that's what I remember. I haven't reread the case since it came out a couple months ago. But that was the first kind of shot across the bow, along with on the kind of business method side of a case we are waiting and waiting and waiting to hear from the Supreme Court on. But there have been a couple pushes lately by the courts against expanding patent rights. So there is some small amount of hope, at least on the patent side. I don't see much hope on the copyright
and who's
side.
pushing that? The courts themselves, or
the companies, the courts are responding. They obviously don't do anything by themselves.
Right, exactly.
But they are responding favorably to the arguments of the people who support pushing back against the broader patenting. So it was, I forget who was part of fighting the
because it doesn't seem to me that it would be
case.
The companies in particular.
Unless it's your competitor and they've locked up something that's so fundamental. But no, it's frequently the public interest groups, various universities, And it's not usually the profit-making enterprises.
So, yeah, I mean, we're in such a slippery slope with this, with genetics. I mean, we really are, because you're starting here with what's naturally occurring in nature that's not manipulated by human beings. We could call that the free and open source genetics. Take it, use it, share it, right?
Yeah.
And then you're talking about things that are actually really truly manipulated and genetic type material that is actually engineered. Now, again, as we go further with this, you have as genetics works, the intermingling of the IP, the genetically engineered, and naturally occurring genetics, and that's where you're just done.
Yeah.
You're in the slippery slope.
Yeah, one of the earliest cases that I remember getting upset about when I started looking at IP, and I don't know, literally, I don't know how I would necessarily come down on the issue if I had to make a decision when it was presented to me as a legal case, but just looking at it. A very early situation where someone's genetic material was taken and turned into a blockbuster, either drug or test for something, and it made the company millions and millions and millions.
This is like the what I would call like the Omega Man type syndrome, where it's like, I happen to have that natural somehow naturally occurring immunity to the plague, and so you take my blood or whatever, and you manufacture the antidote, right? And then make billions of dollars on it.
Yeah, and the person had not given permission for this to be done, had no idea that these tests had been run and that they discovered this, and had no idea that, I think the situation I'm talking about is a guy, although there's a book that came out recently, and I can't remember the name of it, about a woman, I think even a black woman, who was also her blood or some genetic material was used as the basis for some huge some whole series of something, and somebody wrote it up, and it's a book that has come out in the last year or so, and I've been meaning to, it's on my reading list, but I haven't gotten to it yet. But the same kind of thing, where something is taken from you but you have no rights over it. And the decision in that original case that I was thinking of, they said, you have no rights to this.
Oh, man.
Your body produced it, but the company was the one who took it and did something, even though it was against your permission or knowledge.
See, you as the end user should have been smart enough to be able to take that code and do something with it.
Yeah.
So next week on Crazy Talk, debate between author William Gibson and Richard Dawkins, the geneticist. So, oh my word.
Yeah.
Yeah. If only, right? Wow.
I'd be a fly on that wall.
So my brain has just exploded inside my head. So I want to move to another subject that you is on your mind right now. You've been reading the Dan Ariely book called Predictably Irrational, specifically focusing on the difference between market and social norms, and why it's bad to mix them. And you're very excited about this book. We're going to put up the Amazon there. Tell us a little bit about it.
Yeah, I've been meaning to read his work. I hear him talk on the radio now and then, and it's just fascinating. This is behavioral economics, and I'm not an economist, so I don't know all the background,
So
and
describe
I haven't
behavioral economics.
Well, this is just taking human behavior and psychology into account when you're looking at economic activity. We all are familiar with the idea of the perfect market, that the rational consumer, that we always do what's best for us, and that the market will always be right because we are all rational actors in the market. And essentially, if you look at human psychology and human behavior, we all know that that's not true. And so people who are arguing for the perfect market say, well, it may be true on an individual level, but as a whole market, it doesn't work. And of course, with what's happened in the last couple of years, I think we would all say that the perfect market doesn't necessarily work. But specifically with behavioral economics, it's bringing human psychology, human prejudices, human leanings, human intentions, simple things like if someone tells you a number before you walk into a store to buy something, if it's a low number, you are more likely to spend less on this thing. Or, in taking a test, one of the things I think he says in here is he has you think of a number. I think he even uses the last 2 digits of your Social Security. And you think of that number, or you write it down. And then you look through a series of slides and say, how much would you be willing to pay for this? The people with low digits in their Social Security are willing to pay less than the people with high digits. So if the last 2 numbers are 77, you're willing to pay more than someone for whom the last 2 digits are 33. And there's all these kinds of things that we set ourselves up by what's already in our head and the human psychology.
I don't know that I get the correlation there between the Social Security number. Is it just a pure clinical test, or
it's just literally a number? They wanted a random number,
so just
they
get this number in your head, and then go out and figure out what.
And in that sense, we just kind of set ourselves up for. Another example he does is pricing. I think he's talking about The Economist magazine. So online-only pricing is $59. To get the physical magazine for a year is $200. I think it's $199. And then to get online and physical was $199. Same price. So, and he handed this to 100 people and had them say which one they'd pay for. Well, because that freebie was thrown in, the online access as well as the physical one, like 70% of the people took both. They took the $200 online and physical and paper copy. Okay? Because of that middle one. If you throw out that middle one and you just hand someone something that says it's $59 for online and it's $199 for paper and online, then something like 80%, or maybe it was 60, but whatever, the percentage switched, would only take the online. So when you threw in a freebie or something to distract them in the middle, they went for what looked like they were getting something for free.
And I think pricing is a great example, and I think that's been known for obviously for many years. I mean, you talk to your marketing departments when you go price products, and you do a lot of studies to where that price point is, and it seems pretty well. What I'm interested in though is you talk about, for example, you're interested in how companies will treat their employees like a family using the social norms, but then later will use market norms like layoffs and penalties, and that this creates kind of an even worse effect than a stronger effect.
Yeah. So when he talks about mixing the social norms and the market norms, market norm obviously is you pay for something, and the social norm is no money's involved. It's a friendship thing. He uses examples of asking somebody to move your couch. If you just ask someone, will you help me move my couch? People say sure. If you hand them $1 to do it, they'll probably put that couch down and leave. If you offer them $20, maybe they'll help you. But then they start thinking about market norms. But if the market incentive is insufficient, that's where you get the worst reaction. So that's kind of the interesting. And when what he's saying basically is there are places for social norms, there are places for market norms. When you mix them, you often get the worst result. So in companies that try to tell either their employees or their customers, oh, we're like a family, we're all good friends, we're going to be nice to you, that's great. That often inspires higher loyalty. Certainly employment used to be like that, with a job for life kind of thing. But when you mix that with the market, okay, you're late with a payment, boom. There's a late payment penalty. They don't get on the phone and call you and say, hey, is there something wrong? You miss a payment? Or with companies, as you said, they try and do this, but then they expect you to give more. But then when it starts hurting them, they go back to the market. Well, if it was a market relationship from the get-go, I'm buying a service, I'm paying money for it, I don't expect them to be my friend. If they cut me off when I don't pay, I don't really care. I got what I deserved. I don't feel personally wounded by it. Whereas if they've tried to be my friend, if they've tried to pull me into this social norm of we're doing good together, we're friends, and then they cut me off without being friendly and trying to reach out, I will get mad. I will start a Twitter campaign against them. I will say all kinds of nasty things because they crossed that line into the personal.
Well, that's
and
just
then back.
That's just what I kind of thought of there, is that there's so much that we see that we do back to the web and social, social networks and media. Twitter being an example, Twitter is free. We all use it, but we're not paying a fee for it. Yet we have so many requirements around it and cultural, social norms around it. Open source projects and software, especially for those, I've seen developers who are out of work, but, to keep their skills up, they're working on projects for free. Do you deal with any... first off, from the software development perspective, have you ever had any clients that have done that very awkward transition where it's like, I worked on this free project for a long time and now money's involved and now it's messy? I mean, is there anything you've gained from your experience there as far as how that transition can be made? Or can it be made at all?
Yeah, that's interesting. I think I haven't had to face that directly with any of my clients, but I will say I think the most interesting example of it is MySQL and their acquisition by Sun and then by Oracle. By the time they got to the Oracle acquisition, I think it may not have been relevant, but the MySQL, it was a business, more or less, but it was very, it was different than what one would think of as a typical American business, at least. They had much more open, and they did run the company there was money involved, obviously, people got salaries, but it was much more run with a sense of social norms, that people worked together and you could benefit from it, and there was a lot more flexibility in that sense. And then they got bought by Sun, so a lot of money came into it. I think the founders and the top people there knew pretty much what they were getting into when they sold to Sun, and they knew it wasn't going to, it most likely it wouldn't survive. Their atmosphere, their ethos, whatever, was not going to survive. And from everything I hear, it definitely hasn't. So I think that may be our case study for now.
Sure.
There are probably smaller open source projects. Actually, I did one. I did do one that was essentially a one-person open source project, and then a company came along and wanted to buy it up, and they were more than willing to fork it. They were more than willing to leave what was out there, and to let people continue to contribute to it, and even occasionally let the guy they were buying, contribute to it. Not everything, not the proprietary stuff that they were going to build new for the company, but they did. They were going to allow the open stuff to stay open. They just wanted, because one person owned the copyright in all of it, they could fork it at that point, even though it was a several-year-old project. The one guy could assign his copyright to the company, and then they could take a fork private and build enhancements and stuff that they would not release. The company didn't last long. I think that was as much to do with inexperience of management and the fact that the market they wanted to go into was better served by an open source model. There wasn't a lot of money in the market they were trying to go into. So I think it was as much just bad business as it was the forking of the open source, the introducing market norms into what had been a social norm.
Oh, excuse me. That would be bedtime. Oh, I should turn my alarm off there. I think that's a great, actually good, very obvious and good example of a company coming in and saying, okay, we want this and we'll fork it. But you mentioned that it often doesn't seem very successful. That it seems like the open source way, really, once that's established, you can't really break it. That's how things are done. And I know from my experience in technology, where commercialism comes into play in open source projects is often large companies supporting the open source project, like dumping money into it and saying, okay, we're going to be, and they get not only get to add resources and to make that project flourish and gain the spoils of that, but also becoming the good guys, supporting those open source
street cred.
Street cred for being open source supporters and establishing labs and donating equipment and that sort of thing.
A good handful of the really large companies. We've got IBM and
very much so.
And Hewlett Packard, Intel. There's a good handful of companies, all of whom have local presence, who have been able to successfully support some of that, and it's in their interest. But it is a strange situation. I have heard different things from people working in open source in those companies who've said, it's a little weird, having, in a sense, you feel like you have two bosses. Or two masters, in the sense of there's the pull towards the open source, but a lot of them love it because it does give them a salary, it does give them stability, and yet the companies really support their going and doing that. And I think that's one of the best examples, I guess, of where you can mix the social and the market norms. Somehow they've managed to do that without ruining the social side of it.
Oh, very, very much so. And if you see what I saw at Open Source Bridge, and we talked about there, the open source way is very strong. I think the companies you mentioned being very, successful, powerful, strong companies have figured out that balance pretty well with their open source projects. It seems to me, I know that you see several maintainers and folks from those projects who work directly at those companies, and part of their job role is to be maintainer and to work within that community and work for that community for that open source project.
If anything, I'll just point out that in a sense, I think those are the market. The market came first, and the social was put on top of it, as opposed to the other way around. And I think in all the examples that Ariely gives in his book, and the ones that I can think of, the social norm was first, and the market norm interrupted it.
Ah, I see.
So
Very interesting.
I think you might be able to layer. Although I think if one of those companies now came in and said, okay, you guys, now you need to start, making something that isn't going to be contributed back to the open source. Now you need to start making stuff that we can sell instead, that's going to be kept proprietary. I wonder if that would ruin.
I think it's kind of splitting hairs, because you could actually make an argument that that's not the case. That, I mean, if you look way back in academic development, in the Unix world, in the world of the internet, really, that was the early days of the open source way. That's exactly how things were made and how things were done. I think it's just the open source, as we know it today, established and said, okay, we're going to actually formalize this and make this really, what it is. And developers have been working like that for years, well before there was like the big open source projects. Yeah, and I think open source, who knows? Maybe it is unique or at least rare in that it is flexible enough to survive in both worlds. A lot of social interactions wouldn't, and even as we talked about, customer relationships and things like that. It's that. If you get used to the social and then the market is introduced, it can feel rude and not work. But I think if open source, that may be one of the secrets to its success. Well, why so many people, and a lot of it lawyers and large business people, don't believe it can succeed because they don't understand. Right. Yeah, I just thinking back and thinking about working with a maintainer, and I'll tell you, what that guy cares about is his street cred in the open source world. Yes. And rightly so. I mean, it's not. I mean, that's what you do, and that's what's important. Yeah. And other than having to pay the rent, it's often more important than the money. Yes. Yes. The nice thing is if you can do it as part of your job role in a company. Yeah. So I want to finish up here with the really, really big question that's on the mind, and hopefully, we're kind of wrapping up here, so hopefully it doesn't take too long. But it's the really, really big question that you have to ask every lawyer because it's important, and that is this. Everyone loves lawyer jokes. Lawyers always have the best jokes. Can you give us a great lawyer joke? Oh dear, I don't have one. No, I don't have one off the top of my head. They usually end with lots of lawyers dying and someone saying that's a good start. It's a ship sinks full of lawyers. A bus goes off a cliff full of lawyers, and what do you call that? And it's a good start. That's so many of them run that way that it's a little gruesome. So, but yes, I do love a good lawyer joke, and I think lawyers mostly love good lawyer jokes, and we need to learn to take ourselves less seriously. Yeah, well, we'll just have to have you back to bone up on some good lawyer jokes. I think the interesting thing is, we all love to hate lawyers until you need one. Yes. So, thank you very much, Paula. All right, thank you, Doc. It's Paula Holm Jensen. I constantly do that. No Paula Holm Jensen, and I apologize. No problem. It's been great to have a very, very interesting conversation here on Crazy Talk tonight. We'll be back next week with another excellent guest. Good night, everybody.